Yes, good afternoon to everybody. So welcome to the remedial law Tort class, and today is the last but one class, and tomorrow is the last class, which start from the 10 o'clock to 10:50. Thereafter, if you ask me, also I am not going to take any class because I am going to take the class from the 4th October to the All India Bar Examination 16th cohort. Okay, read what I cited on the screen so that I could know that you are with me and I am with you. Yes. Could you see the screen? Could you see the screen?
Yes, sir.
Could you read that Indian Medical Association versus VP Shanta and others?
Indian Medical Association versus VP Shanta and others.
Yes,
A repetition.
this case law that I discussed yesterday. The gist of the case law is like this. See, and she is governed with actually what happened in this case law. It is filed under the Consumer Protection Act. The reason is whether the medical practitioner can be regarded as a rendering service under the Consumer Protection Act 1986 or not. Suppose if there is a medical negligence would be there. At that instance, whether the medical doctor would be held liable or not. Then in this case law, which I discussed in the earlier class, last class, if it is free, then by the government at that instance, or by a charitable institution free, then it cannot come under the Consumer Protection Act. But one thing is very much made clear here is, suppose if the charge is taken over there and the service is not rendered at that instance, definitely the medical council will be held liable or any doctor will be held liable. So Consumer Protection Act will not protect if the charge is taken. That is the same thing which I made it. However, if the customers are being provided for the free to the poor, then it shall be covered. It shall be covered as a service under the Act. Suppose if it is then it will not be applied. In case of the insurance policy, company pays for the treatment on behalf of the customer. Then it will be covered under this act. So now the question comes over there. Suppose if any medical negligence would be there, so one can file a case under the law of tort also, under the negligence, when it is not covered by the Consumer Protection Act. Because when it is not covered, when it is the free, when it is a charged over there, then services deficiency of the services we can say at that time. So that is the whole thing behind it. So now next case law is that is the Sehgal School of Competition versus Dalbir Singh. So it is one of the landmark consumer protection and cases and judgment. A student was asked to deposit lump sum fee for rupees 18,734 for a coaching of a medical entrance examination for the next 2 years. So the next 2 years, the student paid the total fee, means first year fee as well as the second year, means next year fee also for the medical entrance examination. This amount was deposited by the student in 2 complete installments. Okay, very good. However, the student realized that the quality of the education in that institution is not up to the mark. So that is the thing. Therefore, sought to refund for the remaining period. Suppose 1 year he studied it and he paid the 2 years. So rest of the 1 year left out, or that amount of the fee should be paid back to him, but they are not supposed to take it when the services are not up to the mark. So here what did happen, the appellant lodged a case against the Sehgal School of Competition before the National Commission. While Sehgal School of Competition submitted a record that showed a good result of the institute and alleged that it was wrong to observe the coaching service are substandard. So now let us see what is the judgment is happened over there. Because the student said there is a deficiency of these services and there is no proper coaching would be there, but the Sehgal School of the Competition has shown the record to the court that the record is very good and the good result is there and the coaching is very good. It is not a substandard, they said it. Now the judgment is, the National Commission stated that fee once paid shall not be refunded is an unfair trade practice. See, goods once sold will not be returned back. It is an unfair practice, unfair trade practice. See, when they found the defective in the goods or when the size is not improper, then they can return it. Okay, you can exchange the goods. If they not return the goods, we can exchange the goods with the proper size. So it is quoted the UGC guidelines declaring that if a student has not attended a single class, an amount of 1,000 can get deducted and a proportionate charges for the hostel fee and the balance amount could be refunded. Suppose a student has paid the fee, but he has not attended a single class also, not eaten in the hostel also. At that time, nominal charges of the 1,000 will be deducted and the rest of the amount should be returned to the student. So here the State Consumer Forum mentioned that just the balance amount of the fee, but also higher compensation for the legal cost as well as the pain that the student had to undertake should be availed in such a case. But in the later part, what they say, the student suffered a lot to file a case, and there is a mental tension also for the student. At that instance, not only that whatever the remaining amount should be returned back to the student by the management, but again the cost to file the case as well as the other expenses and the expenses like the stress and strain which he has taken to for the continuing of the case, this also should be paid in the form of compensation. And you might have heard that there is in Hyderabad there is a Madina college is there where a student got admission in some good course, so she wants to discontinue it in the second year, but the college management asked her to pay the total 3 years fee, and she paid it later on, file a case in the consumer court. Then the consumer court has given the decision that all the amount which is collected with the management should be returned back except the first year, and the penalty will be imposed over there. So this case law is viral in the WhatsApp also. So if you find the services are not good, you can file a case against the management, against the college, against the university for the compensation. Is it clear? Yes?
Yes, sir.
Okay. Can you read the sixth case law?
Sapient Corporation Employees Provident Fund Trust versus HDFC and others.
Yes, it is enough. So it is one of the remarkable Consumer Protection Act cases. The Consumer Protection Act case happened when a wrongful debit happened from the bank account. What is debit? తీసుకోవడమా తీయడమా? ఎస్
తీసుకోవడం సార్.
ఎస్ ఎస్ క్రెడిట్ అంటే వేయడం అంటే అంటే మన బ్యాంకులో పడడం అని. Okay, the complainant trust, Sapient Corporation Employees Provident Fund Trust maintained an account with the respondent in HDFC Bank. And the bank received the instruction from the employees of the Provident Fund organization, that is the EPFO, that mentioned order of the payment. Okay, next, 1.47 crores against the trust. So, and that no other payment from the trust account be made until the EPO's liability has not been settled by the trust. However, the trust issued an instruction to the HDFC Bank not to debit any amount until further communication, as they wanted to see a stay order. Then, however, in the payment of the statutory due to EPF, the bank, after giving the due time, debit the account with an amount of the 1.47 crores. When clearly the customer said not to debit it, then they have debited it. They challenged the transaction of the deficiency in service and demanded the amount debited along with the interest, damage, and the legal expenses. Trust lodged the complaint against the HDFC before the National Commission on the ground that the bank committed a default on paying the amount payable in the statutory due. Suppose if you lost a checkbook, okay, now you give the complaint to the manager. What? I lost my checkbook. Please, if any checks of these numbers comes, you are not supposed to encash it. After receiving such a bank manager, if he is debit, I mean, if he gives to somebody honor the check, then the bank would be held liable because there is a deficiency of the service. Is it clear? Say yes or no.
Yes, sir.
Okay. The National Commission, what he said, no? The National Commission dismissed the argument of the complaint, saying that the bank informed the trust as its customer and gave them the due time. So it cannot say that the EPFO conducted the deficiency in services. For this false litigation, National Commission has imposed a penalty of the 25,000 on the complainant trust to be paid to the HDFC Bank. So here what the bank says, National Commission dismissed the argument. Why? The complainant is saying that the bank informed the trust. The bank already informed the trust as its customers and gave them due time. So it cannot be said that they have already given the time and they already given the instruction that EPFO conducted deficiency in the services, because in spite of that also, if they debited it over there, when the complaint is given over, at the time, for this false litigation, they made the EPFO. So EPFO made the false statement, and at that instance, the bank also clearly mentioned the warning, but still the EPFO of the National Commission has imposed a penalty to not to file such a false litigation, and 25,000 on the complainant trust be paid to the HDFC Bank. Trust to be paid to the HDFC Bank, because such a statement which is made, the false, which HDFC did not debit it, at that instance, it will be said to be the false statement. Suppose if you make a false statement, false PIL, and it doesn't have the ground for it, then the Supreme Court also imposed the penalty on you to file such a false PIL. I mean to say, not following the proper procedure, not doing the proper things, because the PIL petitions are very more nowadays in the Supreme Court as well as in the High Court. At that instance, if any person makes such a thing, then he will be held liable and the penalty will be imposed on him. So that was the case law where when you make an allegation, you have to prove it. If you don't prove it, it is false. Are you following? So next case law is Delhi Development Authority versus DC Sharma. So in this Consumer Protection Act case, that is a DC Sharma respondent, a government servant, had paid an initial amount for the allotment of the DDA plot, rupees 5 lakhs in 1997. What is DDA? Can anyone? Yes?
Sir.
What is
Delhi Development Authority, sir.
Very good. I appreciate. Yeah, Delhi Development Authority plot in the rupees 5 lakhs in the 1997, and he requested for an extra time to pay the installment as he wanted to avail loan facility from his office. Meanwhile, he realized that the plot allotted to him through a draw of lots has already been allotted to another person 2 years back ago only. Due to this negligence of the DDA, the respondent approached the district forum and dismissed the case. And this case, subsequently, the State Consumer Forum was approached. The passed an order in favor of the respondent. Suppose if the DDA has taken the initial amount, and later on, because in the initial amount they will take it when they are starting the construction, means at the beginning of the foundation. But later on, if that plot is or flat is allotted to anybody else, at that instance, there is a deficiency of the services by the DDA. So the consumer forum or consumer court, means the district, now we don't say forum, we say district commission. This district commission is having a right. Suppose the district commission failed to get it, then we can go to the appeal from the district commission to the state commission. So state commission has given in the favor of the respondent. And subsequently, the State Consumer Forum was approached and passed an order in favor of the respondent. So, in judgment later, we see that how the judgment is there. National Commission stated that when the plot was already allotted to someone else back in 1995, then why the DDA took no steps in correcting its own error in the allotment? They are supposed to make such a correction. It is directed DA to pay an alternative plot for same kind or pay elsewhere, escalate the price to rupees 30 lakhs. So at that instance, the DDA should have to give the alternative plot, or if they want the same plot, then the pay escalate prices are 30 lakhs. Because at the time, the rate of the cement and steel is very much less. So probability would be there when it is hiked over there, then some amount will be paid extra so that it will be given to the respective person to whom it is allotted. So if a thing is allotted over there, you are not supposed to break it. If you break it, means it's a deficiency of the service, and hence you will be held liable. So now let us see the eighth case law, VN Sri Khande versus Anita Sena Fernandez. So here the petitioner, Anita Sen, who was a nurse by profession. So Anita Sen is who is she? Who is she? She is a nurse by profession. Is it correct? Are you hearing me? Are you hearing me? Pakadipalli, are you hearing me? Please say. No one is giving the reply. So, shall I presume that you are hearing me? Anyone? So now I will do one thing. I start sharing this video so that the bandwidth will be more. Yeah, now you tell me, are you hearing me? Say yes or no. Or you type it so that I could see it. Sorry, sir, your voice is not audible. Are you continue your teaching? Okay. So I am continuing my teaching. I am continuing my teaching. So, no, because let me check it whether it is properly functioning or not, so that you could not have such a problem. Okay, let me check whether it is properly going or not. Good morning to everybody. Welcome to the. Yeah, it is going well. There is no problem at all. Yeah. So let you say that there is some because of some your problem would be there. Otherwise, from my side, there is no problem at all. So now coming to the point, and because now I stopped my video so that the bandwidth will be increased so that you could hear my voice. So that is the thing which I want to make it out. So now let us continue it where I left you. Okay, yes. So now it is a judgment is given over there because if the VN Sri Khande versus Anita Sen Fernandez during the discovery of the in this case law, and she is a nurse. Who is a nurse? Anita Sen is a nurse by profession, and she underwent a stone removal surgery from her gallbladder, but they claimed that she continued to experience pain. After 9 years, it is detected that the reason behind this was a gauge a gauge means a swab was left in her abdomen by the surgeon who operated her, and this required a second surgery. Therefore, she filed a charge for the negligence, and a compensation up to the 50 lakhs was demanded by the petitioner. She filed the case against the doctor for his negligence before the Supreme Court. Yes. So judgment is given in this manner is Supreme Court rejected the case on a limitation and evidentiary grounds. So limitation period they will see it. The court held that when nurse was working in the same hospital where the surgery happened, then in the past 9 years, why did not she contact the doctor? During the discovery, a gauge in the abdomen appropriate action could have been taken to an immediate basis without requiring the respondent to pay. But she chooses to consume painkillers. Her long silence dismissed the complaint and she was entitled to no compensation. So now what I want to say is when something goes wrong over there, you have to bring back, but you have to bring the notice to the people. Otherwise, it is not amount to, you don't have any right to claim it because there is a law of limitation was there. So that was the thing. Then the ninth question here, the case is Nizam Institute. Yes, Nizam Institute of, okay. So Nizam Institute of Medical Science versus Prashant, yes, Tanaka and others. This is the case law where we will see that how it is happened. This Consumer Protection Act arises of the complaint of the medical negligence where the 20 years old engineering student was admitted to the Nizam Institute of Medical Science, NIMS, that is in Hyderabad. And after he complained about the acute chest pain, after several tests and x-rays, and tumor was revealed. Though it could not be diagnosed whether the tumor was a malignant or not. Therefore, the patient was advised to undergo the surgical removal of the same. After the surgery, the patient developed a paralysis. There is a complete loss of the control over the lower limb, and related complications also rise, leading the urinary tract infections, bed sores, etc. The family of the patient's health, NIMS, and the state of Andhra Pradesh at the time, statutory liability being the government hospital NIMS liable for this utmost negligence, and the family also claimed that no pre-operative test conducted, no neurosurgeon was present during the operation, and consent was only for the tumor excision, but the doctor also removed the ribs and tumor mass and destroyed the blood vessels, leading to the condition of the paralysis. So now the judgment is given based on the evidence. Supreme Court held that the huge negligence was made out on the part of the doctors and the hospital, and hence the court awarded the damages worth rupees 1 crore to compensate the present and prospective medical expenses and suffering of life. Then you may ask me, then, yes, Ramaraju, are you hearing me? Yes, please unmute and give me the answer. Are you hearing me? Okay. Okay, now tell me that so that I could have to continue it. Pagadipalli, you can tell me, because the first time that you told me that you are hearing me. So now the question is based on the evidence. Supreme Court held that the huge negligence was made out of the part of the doctor in the NIMS hospital, where the person has developed the so and so thing, and hence he will be held liable. So now the judgment is like that 1 crore compensation present and prospective medical expenses and suffering of life was given to him. So that is the case law where it comes. Now let us see what is the Consumer Protection Act. That is the FAQ, infrequently asked question. Sometimes it may be asked in the short questions also. Yes. Again the question comes, yes, I am continuing my teaching. Now tell me whether you are hearing my voice or not. Okay, now let us see that chart. I made it properly. Okay. The Consumer Protection Act safeguards encourage the consumer to speak against the insufficiency or deficiency and the flaws in goods and services. Either goods or services are there both the way. If the deficiencies of services is there, if there is no proper composition of the goods, then it also provides a easy and fast compensation to consumer grievances through the Consumer Protection Act. Then when was the Consumer Protection Act passed? Suppose if such a question would be there, the Consumer Protection Act was passed in 1986. After the amendment, the Consumer Protection Act 2019 came into force. Then it was passed by the Lok Sabha on July 30th, 2019, Rajya Sabha on August 6th, 2019. This is the new act which came into full force on July 20, 2020. Yes, what is the consumer under the Consumer Protection Act? So, if you want to see the consumer, is any person who buys goods or avails the services for its consumption. It includes any person except for the person avails such goods or services for the purpose of commercial or resale, then he could not get compensation under the Consumer Protection Act. For the personal things, that if he purchased the thing for the personal or domestic use, at the time that we can say he comes under the ambit or the definition of a consumer. Now, fourth question generally asked, who can file a complaint under the Consumer Protection Act? The answer is a consumer complaint can be filed by one or more consumers, either one consumer or by more consumers, the central or the state government or any registered voluntary consumer association. Even the state government can file it, and the central government can file it, and a voluntary organization can file it, and a consumer association also can file it, and legal representative of the consumer can file it in case the consumer is a minor. Then the complaint can be filed by his legal guardian or parents. If it is a minor, then the legal guardian would be the person who can file a case against the person who supplied such a goods, or where he find the deficiency of the services are concerned. So that is the whole thing regarding the Consumer Protection Act. Yes, anyone? Ravi Pagadipalli. So,
Sir.
are you hearing me?
Yes, sir.
Very good. Because in the sometimes that I found that, sir, we could not hear you such a SMS means came to me. That is the reason that I asked you. So
Ah,
these are the cases where we can come out. So and next is the last chapter is motor vehicle. With this, I will try to complete as far as today class and the remaining tomorrow is the last class and the classes of tomorrow is because tomorrow there is a law of tort examination, but it is from 2 to 5. Sir, we want to read it. Okay, you can read it, but 50 minutes that you can spare for me, then I can tell you that how to write the examination, how to get the good marks. This secret that I will teach you, I will give you tomorrow, and try to ask the other people to join it. That is because of my good experience both in India and abroad. I know how to score the good marks. I can give the idea to you. Okay. Now let us see the Motor Vehicle Act. What is 1988? This is and why this Motor Vehicle Act? Can anybody will tell me? Unmute and tell me why the Motor Vehicle Act should be needed. Anyone? Yes. Unmute and give me the answer. Why we need the Motor Vehicle Act? Yes. If you don't know it, you say pass on. I will give the answer.
pass, sir.
Why you are taking that much time to say pass on? See, Motor Vehicle Act will be needed. The reason is every person who walks or uses that road should follow certain rules and regulations. If anyone violates the traffic rules, or if any person riding on the two-wheeler or a three-wheeler, at that four-wheeler, they have to follow certain norms, and that is the reason. Number one. Number two, whatever the vehicle, sir, bicycle can be also be insured, sir. Life insurance, bicycle కూడా ఉంటుందండి. Say answer yes or no. ఉండదు. ఎందుకంటే అది మోటార్ వెహికల్ కాదు. మోటార్ అంటే ప్రపోల్డ్ విత్ ద diesel engine or oil engine or electric engine or any other engine. At the time only we can say motor vehicle. Otherwise you don't say motor vehicle. Suppose if you fix the motor to the bicycle, then it comes under the motorbike. Then you should have supposed to keep even a third party insurance. Otherwise you are not supposed to keep that vehicle on the road. That is the whole idea. So third party risk under the Motor Vehicle Act, an introduction. So third party is must, otherwise your vehicle should not be on the road. To understand the relevance of the third party risk, the third party insurance compulsory in nature to get the third party insurance for all the vehicles under the Motor Vehicle Act 1988. Why the third party insurance is needed? Can anyone give the unmute and give me the answer? Pagadiparli. Insurance ఎందుకు
Sir.
ఉండాలా? Insurance ఎందుకు ఉండాలా?
To bear the risk, sir.
ఎవరికి రిస్క్?
Sir.
రిస్క్ ఎవరికి?
రిస్క్ మనకే సార్, ఎవరైతే వెహికల్ హోల్డర్ ఉన్నో వాళ్ళకి సార్.
See, the purpose of the motor vehicle, even for the third person, means there may be probability would be there when you are riding the motorbike or the two-wheeler motorbike or the three-wheeler motorbike or the four-wheeler motorbike or motorbike run with the automobile engine. At that time, there may be the possibility of either with your negligence or the negligence of the other person. At that instant, they say at least the third-party insurance should be there for the motor vehicle to keep on the road. If they don't keep the motor vehicle insured over there, then you will be held liable for the punishment. Both the criminal as well as civil, both the way you can file a case. The police will file a criminal case if suppose somebody was injured over there. At the time that they will file the civil case in the form of negligence under the section 338 of the IPC, rash and negligent driving over there and cause the injury or death to a person who is the passerby. So here, that is the reason that the third party insurance should be there. Then only that motor can live. Now, if you buy the motor vehicle, first and foremost, even a showroom people will add it and they will say, sir, first you have to pay to the insurance, then only you can release the vehicle to you. No, I will pay you later. No, sir, we don't release to you unless until you pay the insurance, because there is a strict instruction from the government in the showroom itself that you have to pay it, either the comprehensive insurance or the third party insurance, whichever is there. But it's a new vehicle, generally the new vehicle would do the comprehensive insurance would be there, because sometimes the difference is only the double. That's all. So here what I want to say is that is the insurance is there. The third party insurance has been defined, the act even in the rules. Thus you will see that depend upon the foreign dictionary meaning. What is the third party insurance that we will see? The Stroud's Judicial Dictionary, third edition for volume 4, in page number 300 and 3019 to 3020, the meaning of the word third party is given over there. So number one, what they said is connotes that the insurer is one party to the contract, okay, that the policy holder is another party, the policy holder is another party, and that is called the policy holder is called the insured, and the policy, those who are making called the insurer, and thus claims made by others in respect of the negligence use of the car or motorbike may be naturally described as a claims by the third party risk. Yes, at that instance, whatever that you got the injury, those who are the insured, you will not get it. But whatever the injuries or damage happened to your vehicle, you will not get it in the third party insurance. Only the third party who got the injury will get the compensation. It will be paid by whom? It will be paid by the, yes, it will be paid by the, yes, unmute and give me the answer. If you don't know, you say pass and I will give the answer. Insurer. That is the answer.
Pass, sir.
Insurer pages later on, if the total negligence on the part of the insured will be there, then he can claim from the insured. That is the secondary question. But the primary question is, first and foremost, who has to pay the compensation to the victim? The insurer. The insurer may be Bajaj Allianz or a United Assurance Company or any other insurance company, either the private or the government, doesn't matter. It will come to the rescue and pay the amount to the victim, those who injured in the accident where his fault is zero. Suppose if his fault is contributory, okay, proportionate amount would be deducted over there, then the next amount would be given. Suppose if you don't wear the helmet and you got injured over there and you are the rider, that means you breached certain traffic rules. That means your contribution will be there in the accident to get the injury more. At that instance, 20% deduction would be there from the total amount. Suppose if you are getting 1 lakh rupees as a compensation in the motor vehicle accident, at that time 20% will be deducted. That means you will get only the 80,000, but not 1 lakh. Is it clear?
Yes, sir.
Okay. In section 145, class Z, third party includes the government, National Insurance Company, and here they give National Insurance Company Limited versus Fakhir Chand. This is one of the case law. It includes the government also. The third party should include everyone other than the contracting parties to the insurance policy, be it a person traveling in another vehicle or one walking on the road or passenger in the vehicle itself, which is the subject matter of the insurance policy, would say to the third party. To whom that you will say the third party? Insurer is the first party. Insured is the, yes. Insured is the second party. Then the third party, other than the parties to the contract, is a third party. That fellow may be a boy or a girl or a citizen or a beggar or a leader or anybody would be there. He is said to be the third party because he is not a party to the contract. So the Motor Vehicle Act 1988 deals with the insurance motor vehicle against the third party risk. So the Motor Vehicle Act 1988, which came into the force in the 1st July 1988, and which is divided into the chapters. How many? Can you tell me how many chapters? Radipalli. మీకు తెలియకపోతే చెప్పండి సార్.
5 chapters. Sir?
ఎన్ని చాప్టర్లు?
5 chapters, sir.
ఇక్కడ నేను హైలైట్ చేసిన చూడండి. ఇది.
Sorry.
ఇది ఎన్ని చాప్టర్లు?
14, sir.
అది 14. సో ఆ నెంబర్ ఏంటిదండి? ఏ నెంబర్ అండి అది?
ఇది రోమన్ అంకె సార్.
రోమన్ క్యాపిటల్ అనాలా?
ఎస్ సార్, రోమన్ క్యాపిటల్స్.
రోమన్ క్యాపిటల్
క్యాపిటల్స్.
ఎస్. సో చాప్టర్ 14 chapter 2017 sections as the two schedules are there, compulsory for every motor vehicle to be insured, and chapter 10, 11 and 12 of the 1988 act deals with the compensation provisions. Section 140 to 144 in the chapter 10 deal with the liability without any fault in certain cases. Hit and run cases అంటారు. హిట్ అండ్ రన్ కేసెస్లో ఎవరు ఇస్తారండి కాంపెన్సేషన్? ఎస్, చూసినోడు ఇవ్వాలా సార్? ది పర్సన్ హూ ఇస్ ద పాసర్ బై విల్ గివ్ ద కాంపెన్సేషన్ టు ద విక్టిమ్. తెలుస్తుంది? ఎస్ అని చెప్పండి, లేకుంటే పాస్ అని అనండి, నేనే చెప్పేస్తా. హిట్ అండ్ రన్ అంటే యాక్సిడెంట్ చేసిండు అండ్ హీ లెఫ్ట్ అవుట్ విదౌట్ ఈవెన్ ఆస్కింగ్ హిమ్ వెదర్ ద పర్సన్ డైడ్ ఆర్ whether got injured. In that cases, hit and run cases, government will come to the rescue of such people. So section 140 to 144, that is the chapter 10, deals with the liability without fault in certain cases, and chapter 11, section 145 to 164, deal with the insurance motor vehicle against the third party risk. So let us see the, still we have the 5 minutes, historical background of the third party insurance. So chapter 8 of the 1939, the old act, and chapter 11 of the new act 1988 has been enacted on the pattern of several English statutes, which is evident from the report of the Motor Vehicle Insurance Committee 1936 to 1937. So in order to find out the real intention of the enacting the section 96 of the 1939 act, which corresponds to the new act of the section 149 of the 1988 act, it is relevant to trace the historical development of the law for the compulsory third-party insurance in England. Prior to 1930, there was no law compulsory insurance in respect of third parties in England. So, as and when an accident took place, an injured used to bring an action against the motorist for recovery of the damages, but in many cases it was found that the owner of the offending vehicle had no means to pay the injured or the defendant of the deceased. In such a situation, the claimant were unable to recover damages. So, in order to get the person should have to get the damages, then a little amount will be paid with the insured to the insurance company. So, it will be benefit to the, I don't say benefit to the insurer, but it will be a benefit definitely when there is no accident to the insurer. If it is not a benefit when the accident took place in the second day of the insurance. It is under these circumstances the various legislation were enacted. To meet the situation, it is for the first time the third party rights against the Insurance Act 1930 was enacted in England. The provision of this act found place in the section 97 of the 1939 Act, it is the old act, and which gave to the third party to the right to sue insurer directly. Subsequently, the Road Traffic Act 1930 was enacted, which provided for the compulsory insurance for the motor vehicle. The provision for this act were engrafted in section 95 to 95 of the 1939 Act and section 146 of the 1988 Act. So 146 will show you that what is third party insurance in the new Act. It is relevant that under section 38 of the English Act of 1930, certain conditions of the insurance policy were made ineffective so far the third party were concerned. So the object behind the provision was that the third party should not suffer on account of the failure of the insured to comply with those terms of the insurance policy. Sir, asal bandiki insurance లేదు sir. Now you tell me. Yes. Insurance ఉన్నది కానీ అయిపోయింది. That expired. Again, they is not renewed. Okay. Now you tell me, who will pay the compensation to the victim? If you know it, you tell me. If you don't know it, it's a person. I will give the answer. Yes.
Pass, sir.
So, if the vehicle doesn't have the insurance at the time of the accident, but earlier it was having the accident, The owner of the vehicle is held responsible. Sir, he is having only a small hut and a wife. All children are got married, and only the wife and himself is staying over there, and that is only one vehicle. Only one vehicle, and which met with an accident. At that instance, let the vehicle will be auctioned. Whatever the amount they will get it, that will be paid to the victim. Number one. Number two, suppose if he is having the assets, bank balance, estate, at that instance, his bank balance would be attached. Are you following me?
Yes, sir.
Yes. సార్ ఒక క్వశ్చన్ అడుగుతానండి, మీరు సావని చెప్తారో లేడు. ఒక బిచ్చగాడు, ఏ బెగ్గర్, వాట్ హీ విల్ గివ్ టు హర్ డాటర్, టు ఏ వుడ్ బి సన్ ఇన్ లా, కట్నం, some rupee, some money. Yes, if you know it, you tell me. If not, I will give the answer. First, he is a beggar, and he wants to get married to her daughter. And the proposal coming by the law, that is the son-in-law, what he is going to give as a katnam. తెలుసు చెప్పండి, లేకపోతే పాస్ అన్నానండి, నేనే చెప్తా కదా. ఐ విల్ టెల్ యూ ద ఆన్సర్. ఎస్
Pass, sir.
సార్ ఒక చిప్ ఇస్తాడు సార్. చిప్ వాని దగ్గర కూడా ఉన్నది, ఎందుకంటే వాడు కూడా ప్రొఫెషనలే. ఏమి ఇస్తాడు తెలుసా కట్నం కింద? అరే మంచి లొకాలిటీ, మీరు ఖమ్మం అండి, ఇది ఏది, ఏ ఊరు, ఏది ప్లేస్, తొందర చెప్పండి.
Kottagudem, sir.
He will give that area where the past locality is there, that jurisdiction he will give the son-in-law to beg in that jurisdiction. అర్థమైందా అండి ఏదన్నా? Did you get my point? Did you get my point? See, sir, no.
Sir.
ఎక్కడైతే
yes.
ఎక్కడైతే బిచ్చం ఎక్కువ దొరుకుతుందో ఆ ఏరియా కట్నం కింద ఇచ్చేస్తాడండి ప్రపోజల్ సన్-ఇన్-లాకి. So now the question comes over there. When such a thing will not be there, what will happen? Then I told you already that they will sell the property of the owner of the vehicle. So if the owner doesn't have any other property, let the vehicle will be auctioned and it will be given the compensation to the victim. That is only the point. For the solace, very rare cases the government will come to the rescue of it. Of course, sometimes Tehsildar will, I think the Tehsildar will having an idea, because certain fines should be there, which are hit and run cases, and it is under the control of the collector. When the control of the Tehsil office will come, the MRO will be having the right. If the funds should be there, certain for the solace to them, ex gratia will be paid to the man and to take care of them. So that was the thing. The insurance is there. If you see the section 149, subsection 2, class B of the 1998 Act, it is found while enacting the 1939 Act and 1988 Act, all the three actions were engrafted in the section 96 of the 1939 Act and section 149 of the 1988 Act. However, in 1939 Act nor the 1988 Act conferred the greater right to the insurer than what had been conferred in English law. Okay, there is some merits are there, some demerits are there. The insurer could contest the claim only on the statutory defenses specified for that statute. Thus, while enacting the chapter 8 of the 1939 Act or chapter 11 of the 1988 Act, the intention of the legislature was to protect the third party rights, not the insurers, even though they may be nationalized companies. So here the benefit will be given to the insured, because first and foremost, if the vehicle is insured, you have to, the insurance company should have to pay to the third party first. Later on, they can think that whether driver is negligent, whether rider is drunken state, whether he doesn't have the license, or any other thing is concerned, later they can think it. But the first and foremost, who has to pay the money to the victim? Yes, tell me. Who has to pay the money to the victim? తెలియకపోతే పాస్ అనండి, నిన్నే చెప్పేస్తా. I will give the answer. Insurance company. Repeat. Then repeat with the air. The insurance company will pay first and foremost. Later on, he can claim the insurance company will step into the shoe and get the compensation from the other people, including the owner if he is at the negligent stage. Okay. So now let us see the next class, the objective of the insurance motor vehicle against the third party risk. Then we'll see the silent feature of the third party insurance in the tomorrow class. Then some of the cases also that is given over there, how the risk could be covered and what are the points would be there in the motor vehicle, you will see it. And regarding the question, maybe ask the long question, what are the salient features of the MV Act of 1988? At that instance, we are supposed to write some of the points which are very much relevant. Of course, if you know the sections, you can cite the section. If you don't know the section, better don't mention the section, but you can give the gist of the sections in your examination. So let us see, the last class tomorrow would be there, and which I am going to start by the 10 o'clock to 10:50 sharp. From 10 o'clock to 10:50, in the duration of the 50 minutes, I will try to cover the main points of the failing features as well as some of the cases I mentioned over there. At the last, I will give if the license is not there, what would be the criteria? If the license is expired over there, what would be the criteria that we will see in tomorrow class. So these are the things which I want to make it out. At any time it will going to be stopped over there. So now tomorrow is the last class. Then I will tell you some of the time that how to get the score good marks and what strategy you have to develop it. How the time management is very much important and the speed writing also very much important. So these are the things which you have to keep in mind. So then only everything will be coming to the picture. If not, and you will be the loser. So please inform to your colleagues and your persons, those who are junior to you, of course, means new people, those who are senior to, those who are having the backlog of the law of TAT examination, because the TAT is nothing but the product of the case law. No case law, no TAT law. No case law, no marks. The case law is very much important. If there is a maxims you should have to be written. You should write the maxims in the examination. If there are any acts are there, then section also important. But don't try to code the wrong section. Better if you avoid it and give the answer only to the question which the gist of the section. If you don't know the actually which section says, even you don't show your ignorance to your examiner.